Hello, welcome everyone. My name is Halley Auger. I'm one of the associates in the Calgary office of Samfiru Tumarkin. As you can see, I'm working from home today. We've got Bubbles here. Hey, Bubbles. No, Bubbles is not in the mood today for any law. And I apologize, it's a little echoey. I would have my microphone on, my headset on, but Bubbles decided that those looked too delicious, and she ate my headset yesterday. So Bubbles is in the naughty chair. But we're hoping today that we'll get some good questions in, help you out with some of your employment law matters. Before the questions come in, I want to direct those who aren't familiar with our blog on the employmentlawyer.ca website. We have our Knowledge Center, which contains a bunch of blogs, which has current employment law news coming out of, companies that are doing mass layoffs, as well as tips and tricks if you have any employment situations going on. So we have a new blog that came out yesterday from Lior Samfiru, our managing partner of the Employment Law Group, and he's talking about PIPs. So a PIP is a performance improvement plan, and what to do when you get one, and more particularly, what not to do. So first of all, don't freak out. PIPs aren't as rare as you might expect. Nobody really talks about them being on a PIP, right? People, I think there's some shame or some stigma attached to it. And frankly, there's confidentiality. So people don't necessarily say, oh yes, I've been put on the PIP, but they are common. They can have a useful purpose. What a performance improvement plan does is, if it's used the right way, it's setting out expectations that the employer says the employee isn't meeting. So, it should be able to outline specific concerns with the work, some expectations or targets that need to be met, and a timeline to meet those targets. And then there's usually a little sentence about the consequences of not meeting the target, which can be discipline up to and including termination. So what do you do if you get a PIP? Usually you're going to have a sit-down meeting with your manager when you get the PIP, and you should be asking questions if there isn't enough information in the PIP about where it is you're falling short. What is the conduct or the omission? What are the acts or the omissions that you're doing or not doing to meet the targets that they want? You should also make sure that these are practical goals, right? If you are somebody who has a book of sales and you're doing, let's say 200 grand a year, and all of a sudden they put you on a PIP and they want you doing $1 million in sales by the end of this year, and you're only on track to do 200 again, it should be realistic. So you might need to discuss the expectations. Now, one of the things that you should do is you don't need to sign a PIP to say that you agree with it. You should be acknowledging receipt that you did get it, but you don't have to agree with the PIP. If you don't agree with it, if it's based on some errors, then you should be also in writing. Since a PIP is in writing, you should be responding in writing with any responses you have to the concerns they've set out, or your ability to meet those targets, or any clarification that you require. That in. One of the things that we've seen that comes to bite people later is when the PIP is wrong for them, and they don't care because they're saying, whatever, I can meet these targets or I can do it. And so even though they don't agree with it, they sign the acknowledgement. That can come back actually, because what some employers do is they use a PIP to try and terminate you for just cause down the line. And it's not likely to be successful. Courts don't really usually look at just a PIP to determine if somebody's terminated for just cause. But what it can do is it can make your termination a little hairy. If you're getting terminated without cause, you're getting your severance. If they're trying to allege cause, it might take some time for you to fight to get your severance entitlement. And if there's allegations of just cause that need to be eked out, then it can take time. So make sure that you're not acknowledging or agreeing to a PIP that is unfair or untruthful. There's no risk, no downside to reaching out and getting legal advice if you get a PIP. Absolutely contact us, employmentlawyer.ca. We are very used to seeing PIPs. We can help you decide how to respond in writing to the PIP. We can help sort of determine if this PIP is being used as sort of a way to evidence, if the employer is using it to evidence them towards a just cause termination, or if maybe this is really some true performance management. We're happy to help you assess those and walk you through it. All right, so let's turn to the questions. We have a question on YouTube from Pradeep. After working for 10 years, my manager suddenly said that he's putting me on a performance improvement plan. Oh, what a coincidence. A manager and HR manager were assigned to my case. They stressed that I go through another performance plan after the first and failed me again. They then called me into the office and threatened to terminate me or resign. I contended that there were many errors, discrimination, and wrongful intent in the PIP plan. They provided me my notice pay of 3 months and pressured that I resign. Do you have grounds to sue them and ask for some compensation? Well, what's interesting about the way the facts have played out, Pradeep, is that notwithstanding that they've put you on a PIP, it looks like they are providing you with your termination pay and some severance anyway. So it's not clear if they're terminating you with cause, in which case you're not entitled to severance, or without cause. If your employer is terminating you without cause, it doesn't really matter what your previous performance is. Whether you are an exceeds expectations employee, a meets expectations employee, a falls below expectations employee, your entitlement is the same. You're entitled to working notice that your employment is coming to an end at some day in the future, or pay in lieu of notice, which we call severance. So if your employer is recognizing that this isn't a just cause case and they're offering you some severance, then I do think you should be turning your mind to negotiating what a fair severance package looks like. And frankly, what a fair severance package look like doesn't give any consideration to whether you were on PIP or not, because it's a without cause termination. There's no such thing as near cause. Either an employee meets that high threshold of establishing just cause. If not, it's a without cause termination and you're entitled to severance. Now, the other thing Pradeep mentions actually is some discrimination. We don't know the details of that, but when I say your employer is allowed to terminate you at any time for any reason, the exception is unless those reasons are discriminatory or unless you are on a period of time in which your job is protected, like a medical leave or a maternity leave. So your employer is not allowed to terminate you for discriminatory reasons and simply provide you with severance. That's not the way the law works. Discrimination is simply never okay, and if it's being used as part of the termination. So you can't be terminated because you're in a wheelchair. That's discrimination. Now, that's not to say you can't be terminated while you're in a wheelchair. Certainly, just because you're a member of a protected class doesn't mean you're guaranteed future employment, but it's the reason for your termination. If you are facing any adverse treatment, whether it's discipline, whether it's a termination, even a termination without cause, it's still negative treatment or adverse treatment, you're still entitled to severance. So Pradeep, it looks like you may be in a position where you're negotiating some severance. One other thing I wanted to raise based on Pradeep's question is sometimes employers do this. They say, we have just cause to terminate you and we're going to terminate you and provide you no severance. But, if you want to just resign and walk away, that's fine. And what they do is really That's not a gift to you. What they're trying to do is have you resign, because if you resign, you're not entitled to severance. Actually, resigning can maybe put you in a position where you might even not get EI. And so in the cases of employers saying, we're going to terminate you for just cause or you resign, do not resign and call a lawyer. Just because your employer says they have just cause to terminate you does not mean it's just cause. It does not mean EI is going to find it to be just cause. It does not mean that a court is going to find it to be just cause. Frankly, it doesn't even mean that the employer's own lawyer is going to find it to be just cause. Sometimes what happens is an employee gets terminated for just cause. They contact us. We say it's not just cause. We write a letter to the employer. The employer goes and gets legal counsel because they see a big scary letter from Samfiru Tumarkin, and their own employment lawyer is going to say, yeah, no, that's not just cause and you owe this guy severance. So, just because your employer says it doesn't mean it's just cause. Contact a lawyer, contact ST lawyers. All right, sorry, that was a long question, but that had a lot of issues, and I think that'll help out a lot of people. Okay, the next question from King Khan. I was fired 3 weeks ago without any warnings after 6 years. A year ago, I asked to go down from 5 to 3 work days. The company accepted without any issues. Within the last 4 months, my workload dropped to 1 to 2 days a week, and the company hired 3 full-time employees within the last 6 months, and obviously want to prioritize them getting their hours. The job I have is extremely technical and scarce. After 2 weeks of not hearing anything from my boss, I've been offered 4 weeks severance. Is this reasonable? Well, no. And my concern is there's a little bit of game playing going on. So let me explain what severance is, the concept of severance. What is it? Severance is the amount of money you would have received had you received working notice, right? That's how we calculate it. Severance, obviously it converts into dollars and cents, but we really calculate it in terms of months and weeks. So it's the amount of money you would earn had you received working notice. So if your employer cuts your hours so that they can then make the argument, had we given you working notice, you'd only be working 1 to 2 shifts a week. So we're only giving you severance based on 1 to 2 shifts a week. No, we know that game. So I'm a little concerned that that might be going on is they cut your hours to reduce, how they're calculating their severance. The other thing from King Khan is that he has or she has a extremely technical and scarce role. And so doing an assessment of how much severance that person's entitled to, it goes back to the concept of notice. So notice is meant to cushion you, to let you know that, you're not going to have a job at some day in the future, which is where we get working notice, or we're cushioning you for a period of time. How long it would take any one employee to find new work is an individualistic exercise. One of the things King Kong is talking about is the availability of comparable jobs in the marketplace. It's a specialized role. Specialized roles will take longer for you to find a comparable job. So for somebody like King Kong, he's not going or she's not going to be able to find a position within 4 weeks. So 4 weeks severance, no, is not reasonable. The other thing for King Kong is it says that a year ago that they asked to go from 5 working days a week to 3 working days a week. And it may be very hard to find another job that will also allow you to work 3 days a week. And so that factor can also go into your ability or inability to find comparable employment because it's a bit unique. It's a 3-day-a-week job, not a 5-day-a-week job. Now, King Khan mentions that his employer hired 3 full-time employees within the last 6 months and wants to prioritize them getting their hours. Nothing's actually wrong with that part. Your employer is allowed to hire new people. And frankly, your employer is allowed to terminate you because they have other full-time employees. Now, that rule applies to non-unionized employees. In a unionized context, obviously that's different, but for the vast majority of Canadians, your employer is allowed to do that. They're allowed to reduce their workforce in any way that they see fit, but if they're doing so, they owe you an obligation. Okay, the obligation is working notice or pay in lieu of working notice. Okay. All right, we've got a long message from Vroom Vroom, so bear with me. Hello, my employer gave me notice of termination. I then informed them that I believe they misclassified me and that as a terminated employee, I'll be owed termination pay, vacation pay, etc. I also mentioned that the CRA can/will make the determination about my employment status. They didn't like it, proceeded to terminate me, accused me of blackmail and extortion. My question is, if the original reason for the termination is not problematic, but then I engaged in a protected activity, i.e. asked them to comply with the ESA and they proceeded to terminate me, is this a retaliation? If not, are these baseless accusations of extortion and threats to report me a retaliation? CRA ruled in my favor, by the way, and I'm currently working on my demand letter. Okay, so from what I'm understanding from Vroom Vroom, they were hired under the guise of being a contractor. So under the employment law spectrum, we have, straightforward employees. You're employed, you get paid an hourly wage or an annual salary. Your employer controls your work hours, your work conditions, you get a T4. You're a regular employee. This is what we think of when we think of employees. On the other end of the spectrum, there's independent contractors. Think about a mechanic. A mechanic works for you. When you bring your car in, he works on your car. He's working for you. However, he's not dependent on you. You're not the only income he receives. In fact, you might only be 1% or 10% of the income that he receives. So he's not dependent on it. The mechanic also may not file a T4. They may actually have their own company. They've incorporated. They may draw a salary, but they may also take shared dividends. Their employer, when I give my car to the mechanic, I don't say, you have to start working on it at 9 a.m. You have to stop working on it by 5 p.m. I don't control his working hours. In the middle, there's this category called dependent contractor. That is where there are some elements that make you kind of like a contractor, but you are dependent and usually financially dependent on one single entity. So Vroom Vroom has an issue about where on the spectrum they fall, if they're an employee, a dependent contractor, or an independent contractor. Now, Vroom Vroom has pointed out the fact that CRA has made an assessment of their employment category. And the CRA does it for a few different purposes. Oftentimes, it's for paying into CPP or EI. For the purposes of paying into CPP or EI, they may consider you to be an employee. That decision can be persuasive on whether you are an employee, a dependent contractor, or an independent contractor. However, it's not binding. So it's one factor that goes into the assessment. The area of law we work in, and that means that we would go to court, so we are civil, meaning our rights are determined by a judge. A judge gets to use his or her own factors and his or her own legal test to determine your entitlement, and your entitlement to things like termination pay or vacation pay or overtime pay or ability or the requirement to pay for your own uniforms, those types of things. The other issue that Vroom Vroom brings out is retaliation. Retaliation is a very, very narrow concept. If somebody is asserting their rights under legislation like occupational health and safety or human rights legislation or employment standards code legislation, and they face adverse treatment, cutting the pay, cutting the hours, getting termination, those can be retaliatory terminations. And so depending on sort of what the reason for retaliation is, you might have different remedies. So for vroom vroom, it could be retaliation, but what that means is, are you entitled to reinstatement and back pay? Are you still just entitled to some severance? Maybe is there some bad faith? So in addition to severance, you might be entitled to bad faith damages. Bad faith damages are when they're rare, but they're awarded when there's particularly high-handed, egregious misconduct at the time of termination. Retaliatory terminations often can result in bad faith damages. So vroom vroom, if you're working on your demand letter, certainly reach out to employment lawyers. We're happy to help. stlawyers.ca, go to employmentlawyer.ca to find us. Actually, you can even email us at help@employmentlawyer.ca, and they can help put you with the right lawyer. All right, question on YouTube from Bethany. I'm currently stranded out of the country because of the AC strike. Oh, right, I'm assuming Air Canada strike after traveling for work. They are now telling me I won't be paid for the days I am stranded. I was paid for the days leading up to. Does my employer have an obligation to pay me for my time while I'm stuck here? Company dealt with booking my flights, but won't help me find any alternatives. All right, Bethany, it's hard to say because we don't know if you are a hourly employee who's paid by the hour or a salaried employee who's paid by the year. It also depends on what your employment contract may say. This is obviously a unique situation, because it's an Air Canada strike. So it's not exactly your employer's fault that you can't work, but it's also not your fault that you can't work. So I don't know if there's going to be an answer at law for you. And I don't know how long it's going to be or how much, because if you're off work for a day versus 2 days versus 3 days, for how long, it sort of depends. Obviously, it sounds kind of bad. I mean, it's not your fault you're stranded. You're there on a work trip. I don't know the kind of work you do and if it's work you can do while you're stranded and traveling out of the country. Unfortunately, I just don't have an answer for you because it's probably not something you're going to find in law because it's not exactly something that, a court would probably deal with, because if it's just a few days' pay, who goes to trial over that? What I will say is that we have this concept at law in Alberta. It's actually a concept at law across the country, but I'm an Alberta lawyer, so I'll tell you about at law in Alberta. If an employment agreement is frustrated, that means it can't be performed by, through no fault of the employee and no fault of the employer, then the employment agreement can be frustrated. I don't think we're at a period of time where it's frustration of contract, because the entire contract can still be performed. We're talking about maybe a couple of days. But yeah, with the information we have from Bethany about whether she's an hourly employee, a salary employee, a commission employee, I'm just not sure if we can add it, but don't hesitate to reach out, employmentlawyer.ca. Okay. Another question from Vroom Vroom, asking for a friend who's an employer. Their employee went on a lengthy sick leave until further notice due to mental issues and provides note from a support worker, not a doctor. So there's no proper doctor's note. There's reasons to believe the employee is engaging in a protected activity just to protect themselves from termination. How can an employer handle this situation? All right, so great question. It's not really up to the employer to decide if that is a legitimate medical leave or not. An employer is allowed to ask for medical documentation if somebody is on an extended leave. You're not entitled to know what the medical condition is, but the employer is entitled to know what some limitations are. Oftentimes the limitation is, this employee cannot perform any duties for the next, week or 2 weeks or 6 weeks or whatever for a period of time. Sometimes the accommodation is this person is limited from, lifting heavy things or, standing for a certain number of hours. So the employer is not allowed to know the medical condition, but they are allowed to know the restrictions or the limitations, which may in turn lead to any accommodations. So that's because if the employer finds out that the employee can't stand for, more than an hour at a time, the employer is allowed to say, well, we can accommodate that. We can find you a job to do where you can sit or you can take frequent breaks. So the employer is allowed to try and accommodate. And so what I would suggest is probably try and get some more medical information rather than just, if this is a sort of a long period of time, rather than just get a little medical note that says, until further notice. Maybe try and get a medical note filled out by a doctor that sets out the limitations. And then the employer can see if they can accommodate by returning that employee to work. If there's no medical documentation, I'd probably tread lightly on how long you let it go before that employee gets medical documentation. It's the summer. It can be hard to get in to see a doctor. Sometimes it can take a week or two. And so, give the employee ample opportunity to get in to see their family doctor to get the medical notes required before you take any steps. Just because you think the employee may be making it up to avoid discipline or termination doesn't mean that you should not tread carefully, because you just don't know what you don't know. Oftentimes an employee may have performance issues, and those performance issues can actually be tied to a medical issue. You may have an employee who was a great employee for 12 years, and in the last 6 months, they're not showing up, or they're not really, meeting their targets. Failure to perform can be tied to some of those protected grounds. So tread carefully. If there are some specifics that you need, if you need more information, don't hesitate to reach out, employmentlawyer.ca. We are employment law experts, whether you are an employee, whether you are an employer. We love doing both. I love doing both. I like representing employees, but I also like helping employers make sure that they are protecting their employees and protecting their business. Okay. Question on Facebook from Stitch. I've been working as a seamstress at a boutique clothing company for the past 3 years. Last week, my employer told me they're moving all employees to a piece rate payment system, meaning we'll only get paid per garment finished instead of our hourly wage. This wasn't part of my original contract, and I'm worried it will drastically cut my income. Can they legally change my pay structure without my consent? Well, you didn't say what province you're in, but if you're in Alberta, your employer can change your compensation as long as it's not significant. So if it's just a little change, they can do it. Your employer can change the way you get paid as long as it doesn't change your overall compensation. And so you need to be able to put it to your employer and say, based on how many garments I complete a week, this is actually going to be a pay cut. And because it's a significant change, you need my consent in order to do it, and I do not consent to this pay cut. Then the ball is in the employer's court. They can say, okay, fine, we will keep you on an hourly rate versus a per garment rate. Or if they insist on the change, you can treat your employment as a constructive dismissal. That means you haven't been terminated, nobody's actually handed you a pink slip, you haven't been terminated, but in effect, the employer is demonstrating that it no longer intends to be bound by the employment agreement. Okay, so if the piece rate isn't changing your compensation negatively, then it shouldn't be a problem. If it's a significant negative change, then you don't have to accept the change. If you tell the employer you don't accept the change and they insist on it, you can treat it as a constructive dismissal. I'll leave you with this because we're out of time today. If you are in a potential constructive dismissal situation, contact a lawyer as soon as possible. We want to make sure that you don't do anything that ends up shooting yourself in the foot because you can be seen to be resigning. We often help employees out in these situations. We can help guide you in the right direction, whether it's going to be getting your employer keeping your wages the same, or whether it's going to be getting you to a severance entitlement. Don't reach out too late. Let us get involved as early in the process as possible. All right, well, that's all the time we have today. You guys are back next week. Actually, you're back tomorrow with Lior Samfiru. And so you'll be in great hands, and he'll wrap up any questions we missed today. Other than that, I'll see you guys in a few weeks. Bye.